Hello, this is Clifford Enoch, and in this video, I'm going to show you how I managed to, shall we say, create a case digest from scratch, starting from scratch. And by the way, I'm recording this for my audience in YouTube. So please subscribe to my YouTube channel. Thank you. And I'm going to show you my screen right now. Okay, so right now I'll be showing you. I think I have my picture there now. Uh, the bottom left, so probably here. Okay, so I'm going to open my um, enable my noise cancelling. Okay, so I'm using a note taking or PKM or product knowledge management uh, application called Logseq. All right. So if you don't know, you can search it on Google. Pwede nyong tingnan doon G and then SEQ. All right. So in this case digest that I'm going to read from scratch, I have no not yet. So I have already a template for, shall we say, the facts, issues, and then the ruling. And then I also have installed or downloaded a PDF copy. So this one is the PDF. So right now, I'm going to show how I managed to record and outlined. By the way, this is an outliner, and later malalaman nyo kung ano yung ginagawa ko or ano yung mga pamamaraan. So I don't. This is 17 pages, so ang haba, no? But anyway, um, I'll be uploading this later after na matapos, and then, alright, so let's dive in. Okay, so I'm going to turn off my camera there, and so here dito, um, wait, let's make this bigger, no? Okay, so title, we have here ng reference, citation. So ito, so copy ko yan, just make that copy and paste here. But pwede rin, another way is to probably one of the better way gawin ko is color green, and then I'll copy the reference and paste it here. So nandiyan, oh, kikita natin dyan. So that's the citation source. Of course, this is online from that website, particular website. Okay, and mnemonic, wala pa akong mnemonic, but this one is from our CIBPRO, civil procedure topic. I'll check civil procedure, and it's, I think, rule 12, rule 12, bill of particulars. So, and then nasa section 1. So I'm trying to grab that and paste it here. No? Yeah, yan. And then I'm going to have the color. Okay. So that's on my, according to my syllabus, civil procedure, section 1, and this is rule 12, bill of particulars. Bill of particulars. Okay. So tapos tayo dyan sa title and mnemonic. Later na yung mga keywords, ganyan-ganyan. Kasi hindi pa natin alam. And I'm going to add that later or soon. May iba ng topic dito pala yan. So I should have put that here. Dito. Okay. So that's mnemonic. Now let's go to, start na tayo sa facts. Let's go to the facts. So ganito ang gawin natin. Facts. Simplified version. I have a template na yung isang case digest. Medyo complicated siya kasi maraming lagyan mo pa ng dissenting opinion, concurring opinion, kung sino yung mga kanilang mga counsel, mga ganyan-ganyan. But to simplify and make it faster sa pag-digest and also to synthesize. So ito yung gagawin ko. So let's start with anong tawag nito? Procedural history, what happened from the lower court and then ganyan-ganyan. But okay, let's ang ginawa ang ano dito is resolution. So this is a resolution, no? And then okay. So the propriety of filing and granting a motion. Sana makikita niyo diyan or ano gawin natin malaki, no? Para you can also read what I am reading here or ano. Dali ha. Adjust natin. We'll adjust adjust ba to? Adjust. Yan. Okay, na-adjust na. So gawin natin is ito yung introduction. So puluran muna natin ng yellow yan. The propriety of filing and granting of a motion for a bill of particulars filed for the estate of a defaulting and deceased defendant is the main issue. Oh, the main issue. So let's just skip it. Yan the main issue. Let's go to issues. Ibig sabihin, let's just copy the reference here, paste here. The propriety of filing and granting of a motion particular filed for the estate of a defaulting and deceased defendant is the main issue in the saga of protracted legal battle between the Philippine government and the Marcoses and alleged wealth. Okay, so ito na yung facts, antecedent and pertinent facts in this case. The antecedent and the pertinent facts. So balik tayo doon sa facts. Ito. So mahaba-haba to. But how can we fast track in understanding bill of particulars? Kasi yun yung target natin dito for civil procedure in a way na we can get it faster, no? So ito yung mga ano parang telenovela no, going to have a base tawag doon, or parang start from the beginning ba kung ano nangyari. But so ano ba? In a nutshell, in a reply, yung mga ganyan. So ito yung mga we rule in negative dismissal or lack of merit. Okay. So I'm looking for a particular when we're going to direct to the point, no? Actually, kung tutusin natin, ito mahaba to, no? 17 pages. Isipin natin, and I'm going to read it one by one, parang ma-overwhelm talaga. So, here, um, um, I'm going to make a sense. I'm just scrolling, okay? So, okay, so hanggang 13 pages for all the, kasi itong mga other, 14 to number 14, 17, so ano na to, mga footnotes, references. Okay, so, let's go to this dispositive portion, copy ko muna to, or highlight pala, highlight. And let's go back to to my digest ruling and dispositive disposition here. So I'm going to paste that reference. So alam ko na. So ang nangyari dito, no? Finding no grave abuse of discretion on the part of the Sandigan Bayan and granting respondents motion for bill of particulars. So the petition is dismissed. Mhm. So na-dismiss ang petition, um, part of the Sandigan Bayan. Okay, so balik tayo again. No, this is for educational purpose only and a disclaimer. Um, this is not there's no substitute for the best teaching or learning. No, this is not. This is only for educational purpose only, and there's no substitute for better understanding, better about the law than to have a formal or enroll in law school. No, all right. So let's go back. So, ang nangyari dito is sino yung mga petitioner? So, yung nangyari dito is the petitioner is the Republic, right? Let's go back there, up, go back. Um, and then the respondent is Sandigan Bayan et al. And then but the respondent also is includes Ferdinand R. Marcos Jr., who is the executor of the estate of Ferdinand, the late President Ferdinand E. Marcos. And then the petitioner is the Republic of the Philippines, which that represented by the PCGG. That was before. Ngayon wala na. Or I think na during those times lang naman yun, from what I learned, I understand. No? So, right now, wala na PCGG. Okay, so let's go to, so kung gawin natin dito is title niya. So I should have a reference for the, so understandable naman yan ng mga, kung sino yung petitioner, and then sa left side is the petitioner, the right side is the respondent, yung mga ganyan. So let's go to the facts. And ang maganda dito is ano yung nangyari, mga antecedents. So, Republic versus Sandigan Bayan, ang nag-start ng ano ng tawag dito, facts is dito nag-start. So, I'm going to copy this first. I think that one or color this one, pink. And going to add this one. I'm going to copy the reference. Oh, at meron dito sa taas. Copy reference. Need to go that start. So, so wala na to dapat. I'm going to remove this. So the administration of the then President Aquino successfully sued former President E. Marcos and First Lady Imelda under alleged cronies of the dummies. Maganda ang highlight natin. No? Mas maganda. I think makikita ba kaya dyan? I don't know if makikita dyan so parang hindi. I'm going to escape because I'm running on an app, and what I'm going to do, I'm going to here. All right. So balik tayo, no? Wait. Lagyan ko ng color apprehend. So I'm using a pink, no? Or orange na lang. So, the administration, you know, so ito, the same. The administration of the then President Coronel successively sued, and then the alleged cronies, ato, for dummies, anti-graft court to recover the ill-gotten wealth, blah blah blah. Huh? Blah blah blah. Actually, we do that to state that ang haba-haba yung ganyan, ganyan, ganyan. Okay. And then, pag July 21, 1987, PCGG through the Office of Justice filed a complaint for reconveyance. Ah, okay. So, ito na yung complaint. Going to do, again, copy or color, highlight, and copy the reference. Is it, ano, ang tawag nito? Sa Bisaya pa, tinapulan, no? Tamad na way of, but actually, when this case digest to be submitted, hindi yung word for word yan. Ito lang is more on understanding and then para malaman natin, no? Basta, what we know is that the ruling of the petition was dismissed. No, ito, na-dismiss siya, no? So, go back. Go back. Uh, and then, yan, timeline. Yun yung mga timeline. Mas maganda may timeline din. Lagyan natin ng date sa start. So 21 July 1987. Yan. Ito naman is 18 September 1987. So si Cruz nag-file ng omnibus motion to dismiss to strike out abetments in a complaint and for a bill of particulars. Huh? Okay. Yang ito no. Let's go. Let's drill that down. Cruz filed wait. Filed an omnibus motion to dismiss. Motion to dismiss. And then strike out abetments in the complaint and for a bill of particulars. Ah, okay. Bill of particulars. I have some bill of particulars. Let's check. No? I have notes on bill of particulars. So motion for bill of particulars, and although under the rules, the defendant is required to answer the complaint within 15 days from service of summons. Right, huh? The defendant need not file his answer to the complaint within the required period if there are matters in the complaint which are vague or ambiguous or not averred with sufficient definiteness. Instead, may file a motion for bill of particulars. Ah, okay. Pag sinabi dyan, hindi siya na-averred with sufficient definiteness, pwede siya mag-file or he may file a motion for bill of particulars. Yan. So, nangyari dito, Cruz filed a motion to strike out the bill of complaint and for a particular. So, ginawa niya is, no? Strike out ang abetments and for a bill of particulars. So, kasama ang bill of particulars. So, when to file the motion of bill of particulars? Actually, sa notes ko to previously na ito. Aha, okay. Aha, 30 days. When to file? Ang yung kanina, wait, my reference here, I think this is 30. 30 na siguro nito. When to file? A motion is filed before responding to a pleading. So i-file yung bill of particulars, no, before mag-reply or mag-respond sa pleading. Okay. And then the period to file the motion refers to the period for filing the responsive pleading found in Rule 11. No, Rule 11. Thus, where the motion for a bill of particulars is directed to complaint, so the motion should be usually filed within 30 calendar days after service of summons, as provided under Section 1 of Rule 11. Section 1 of Rule 11. Let's check or asa naman to? Asa na ba yung Rule 11? Rule 11, Section 1. I think we're going to search that. Rule 11. Ito. Rule 11. Dito. When to file responsive pleadings. So, ito na siya. Nakalagay dito 30. So, it should be 30 calendar days after service of summons unless a different period is fixed by law. So, 30 days. Nakalagay dito 15. So, could also within 30 days to. So, going to update real time notes. My notes calendar days. This is the calendar days from service of summons. Okay, so I think okay na, balik tayo doon sa case. Let's check the case below particulars. And then abearments. I have topic for abearments. Abearment like material abearments. Abearment. Abearment. A positive declaration or affirmation of fact. So material allegation. So in a pleading, an assertion that is essential to the claim, charge of defense, a material allegation in a battery case is harmful to or offensive contact with a person. So if it's a immaterial that allege something in needless detail, a statement that goes far beyond what is issue as by mentioning relevances. This type of abearment may be ordered struck down from the pleading. Okay, so clause of jurisdiction, I have linked references. Let's go back. So, abearment sa complaint. Okay, balik tayo doon sa facts and yung mga dates, no? Ito. Let's go back to, meron siyang 18 of April, 1998. Do that, like that. Colon. And the court ordered that alias someone says okay, our professor, a very the best civil procedure professor, no, simple, serve on the Marcoses who were then exiled. So ito yung sa pag-April, no. Ito lang muna. Let's copy that and highlight so I can have that reference and paste. The court ordered that alias summonses be served on the Marcoses who were then exiled in Hawaii. And then the court likewise admitted the PCGG's expanded complaint. Actually, ito yung mayroong annotation dito sa PDF from this site, no, na ginawa kong PDF din para malagay ko dito. And then complaint April 25, so April 18, April 25. Then denied Cruz omnibus motion. So okay, let's dissect this. Mhm. Si Cruz, then President and General Manager of GSIS, President of PAL, Chairman and President. What? The administration of then go back to facts na. Nakalagay dito is that itong si Cruz, no? Roman A. Cruz Jr., President and General Manager of GSIS. Yung president po siya sa PAL and then a chairman and president of the Hotel Enterprises of the Philippines. Owner of chairman and president and chairman of the is the alleged crony in this case. Oh, all right. Very interesting. And then so the president commission and through the officers. Okay, let's go to here. Wait, dissect natin to. This is 13 pages all in all, excluding the footnotes. And then I'm reading this right now, not a wala kong alam dito previously. So this is just a um tawag doon, real time recording or real time learn as you go, or shall we say learn as you go. Ah, here. Come left, come right. Okay. All right, go. So balik tayo dito. So we can proceed. So ang nangyari, ganda to, maganda. Gawin kong ano, ito yung facts, but I'm going to add here yung ano, itong si Cruz. I'll make it a separate block, no? Because ito yung ano siya yung the alleged crony. Crony in this case is the alleged crony. Actually, not only Cruz. No? Because actually, ang nangyari to, the administration of the then successfully sued Marcos, Imelda, and under alleged. So, is this Cruz is not only one, and their alleged crony. So, hindi lang si Cruz, kasi mga alleged cronies, marami sila, di ba? Or dummies before the anti-graft court to recover the alleged ill-gotten wealth that they amassed during the former president's 20-year rule. Roman A. Cruz Jr. Cruz, then President, GSIS, PAL, and CBM. Okay. So let's do this. Ito, under siya sa kabila. Yan. And then let's highlight this. And then kasama siya sa kabila. Yung mga stories niya. The court ordered the aliases Sumonses be served in the Marcoses who were in exile in Hawaii. Ito yun. And then the court likewise admitted this. And then, eto. The court likewise admitted the PCG's expanded and then denied omnibus motion. Copy. So, ito siya. And then, na-denied was July 28, 1988. Yan. So, denied Cruz omnibus motion after finding that the expanded complaint sufficiently states state causes of action. Okay. Ito yung mga topic namin, cause of action, causes of action, you know, causes of action, and that the matters alleged are specific enough to allow Cruz to prepare a responsive pleading. So enough, and then to prepare responsive pleading. And then on September 15, 1988, Cruz filed his answer ad caut ano to? Cautilam. Aha. Huwag muna natin yung i-search kung ano yan. Mamaya. So, this is 15 September 1988. Hmm? Ano yan? Highlight natin ito. Mga dates. 18 April, 28 July, 15 September. Cruz filed his answer ad cautelam. Cautelam. Okay. And then, so, may mga timeline hanggang, haba, no? November 10, November 29, July 13. Okay, so, I will have to, ano, check kung pwede natin ma-skip, no, some of the, kung kailangan lang ma-skip. You need to, kasi, will not forget that our topic is about, tawag nakalagay doon. Topic is when applied for purpose bill of particulars. Okay. So I think ito na yung mga nangyari and then blah blah blah, respondent motion, blah blah blah. So issue. Issue tayo, so na sa issue. Let's go to issues. Kasi nakalagay dito the propriety ito yung the statement, the started the statement. And the main issue ko now is that sa protected legal battle, the propriety of filing and granting of a motion of particulars. So I think that the propriety. Let's copy that. The propriety. Copy text. Siya. This is the main, ito yung tinutukoy. So let's have that pinned, no? And then going to remove that. Bali yung main issue. And let's check, meron ditong issue. The issue in this case, yung mga ganyan. Right. Ito na yung last time. Is motion of bill particulars. Respondent wanted clarification the specific nature and extent of the participation of his father in acquisition of assets cited above under Cruz, particularly whether former Marcos was a beneficial owner of these properties in a specific manner in which he acquires his beneficial control. All right. So, the main issue, and then let's go to the Supreme Court ruling. ang nangyari dito I cannot, ito mayroon na siyang ruling, but I think ito gawin natin yan. We rule in the dismiss the insubmission. Okay, so the ultimate issue, in a nutshell, the ultimate issue, hanggang dyan lang. Ah, did the court commit grave abuse of discretion amounting to lack of decision granting respondent's motion to be as executor for Marcos State, considering the deceased defendant was then a defaulting defendant when the motion was filed? So, ang rule ani, because it's negative, none, not. So it did not commit. The court did not commit grave abuse of discretion amounting to lack or excessive decision granting respondents motion for a bill of particulars as executor of former President Marcos' estate, considering that the deceased defendant, the President Marcos, late President Marcos, was then a defaulting dependent when the motion was filed. So, mga na siya ang copy. Ito na yung ruling. Let's go to the ruling dito. And then I'm going to copy that reference and go back to the issues. The issues here is this one. And then answer. Ito na. So held. We rule in negative and dismiss the decision for utter lack of merit. So, sabihin, yung petition ng Republic, no? The Republic's petition, if they if the court, which is the Sandigan Bayan, right? Second division, and commit grave abuse of discretion. So hindi siya nakakommit ng grave abuse of discretion. So okay. So alam na natin na nangyari that the petitioner for filing the petition that the court commit grave abuse, which did not, or the Supreme Court ruled in a negative and dismissed the petition for utter lack of merit. Nga. Ang ilahang complaint is that naman to, finding the complaint sufficiently state of Cruz filed an omnibus motion to dismiss strike agreement complaint. So ito yung, and then Cruz filed answer ad cautelam. So so dito yung this, let's continue reading this kasi dito yung nangyari. Now, on November 10, 1998, the alias summonses on Marcos were served sa Hawaii. Then the Marcoses failed to file an answer and accordingly declared in default by the anti-graft court on 1989. And then Marcos, another case ni siya, et al. Versus, this is Imelda versus Gachuterain. This court upheld the validity of Marcos' default status for failure to file an answer within 60 days. Na default, no? Kaya wala man siya mag-reply. So, na default within 60 days when the alias summonses were validly served in their house address in Hawaii. And then September 29, 1989. This one is 1988. 1989, April 6. Former Marcos died in Hawaii. So, si Marcos namatay sa Hawaii. That was 29. He was substituted by his estate, by Miss Marcos and the children upon a motion of the PCGG. And then July 13, 1992. So that was after 3 years. Miss Marcos filed a motion to set aside order default, which was granted by the Anti-Graft Court, PCGG. In Republic of Bayan, this court affirmed the resolution. Kasi ito na yung resolution. Okay, so Mrs. Marcos had a meritorious defense. Meritorious defense. The failure of party to properly respond to various complaints brought about by the occurrence of circumstances which ordinary prudence could not have guarded against, as being barred for returning to the Philippines, numerous civil criminal suits, and draining health and husband and publicity of legal basis considered due to fraud, accident, and excusable negligence. And 1995, Ms. Marcos filed her answer, cueing the former Marcos wealth is not gotten and the civil complaints proceedings are void for denying them due process. Just a question of the legality of the PCG Act and asked for 20 billion moral and civil damages and 10 million attorney's fees. Wow! Ito, ganda, 10 million attorney's fees. January 11, 1999, after pre-trial visa filed with Cruz with Ms. Marcos, court detected former President Marcos children to appear before proceeded pre-trial proceedings. And then 1699, respondent filed motion for leave to file responsive pleadings. Securities late party district opposed the motion, citing the ground absence of motion, order lifting status to the former President Marcos. On May 28, 1999, drag down talaga, no? 1986, 1999. Ilang years na yan? 13? Yeah, 13 years. Court granted respondent motion. The court conceded the speediest strike. Both merely derived the right to any incident considering how electricities and according to Marcos, blah, blah, blah. Respondent asked for 3 extensions, 35 days to file an answer. So, extension, yeah, total 35. The court granted a motion given July 17 to file an answer, but instead filing an answer. Motion of birth particulars, praying for the clearer statement of allegation. Oh, here. Called a mere conclusions of law, too vague, Okay, so yan. Aha. So, file siya because tawag doon, clear statement allegations. May conclusions of law, blah, 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 like that. And let's go back to my, ano ba yung topic is here. Oh, when applied for purpose. Yeah. Ito. May sagot na dyan. When applied for purpose, yung kanina binasa ko, kung vague siya, 'di ba? Yung hindi siya clear. I think I have a bill of particulars. I have already tagged that or read yung kanina. But let's go back and check. Nasaan na ba yun? Bill of particulars. Ito. Ito sa facts natin. I think here. Where was it? Here. This one. Bill of particulars. And then, when applied for purpose, is ito. Pagka ang pleading is unclear or the purpose, ito yung purpose. It is to seek an order from the court directing the pleader to submit all the particulars with averse of matters with sufficient definiteness or particularity. Wow. Ito na yun. So, finally, we can have a conclusion or we can have tawag doon, a completed digest na. Na yung purpose, definiteness, dapat sufficient definiteness or particularity, kaya nga bill of particulars. No? To enable the movement to properly prepare his responsive pleading para makapag prepare, tama. sa kanyang responsive pleading. The motion is not availed of for the avail the movement to prepare for discover the evidence and first party for such purpose. The appropriate tools are necessary procedures from Rule 2329, um, Military Pretrial and Rule 8 under Rule 18 and Rules of Court. Okay, and I'm going to close this, but now let's continue diving the issue of this particular case, Republic versus Sandigan Bayan. Teka pa na. Tanggalin natin to. Okay. So, let's go back. And then, how minutes did ilang minutes na ba? 1 hour and 15 minutes. We're almost. Teka, 40 minutes? Okay. So, Republic versus Sandigan. Sandigan. No? Sandigan. Okay. Up. Yeah. Republic versus Sandigan Bayan. Sandigan. Okay. And then the title or citation, 148 GR number 148154. So, ano nangyari? What is the facts of the case? So, nangyari dito is that during the time of Cory Aquino, president, naging president siya, the president sued former Marcos and Milda under alleged cronies, and then at ito si Cruz, no? So Roman A. Cruz as the alleged crony in this case. And then so mayroong mga timeline dito, and then mayroong mga nakalagay diyan ng mga alleged purchase, blah blah blah, mga kasi the government, no, mayroong binuo na anti-graft court, the PCGG, to the office of the OSG, no, nag-file sila ng complaint para reconvey yung mga reversion, mga accounting talent restitution damages alleged that Cruz and Marcos stole public assets and invested them in several institutions here and abroad. Specifically, Cruz allegedly purchased connivance from Marcos assets of disproportionate or illegal income to it, dalawang residential lots and two community Baguio, residential building Makati, Marisol of land, and six. Ang dami. You say resident land and procedures of prey for the payment of moral damage of 50 billion and exemplary damages of 1 billion. Magkano kaya ang attorney's fees? Meron kanina nabasa ko 10 million attorney's fees. Yeah, pag ganun talaga, no? Pagka malaking cases or malaking kaso, case lang, not cases. Pwede rin kung marami, mga malalaking billion-billion na case, no? Involved. So malaki din ang attorney's fees. Okay, and then ano nangyari ito pag September 18, si Cruz, file siya ng motion to dismiss, strike out aberments, the complaint, and then ordered na i-serve ni Marcos. But, itong marami itong mga timeline dito, and then nag-file ng answer si Cruz. But regarding those issue is that kung ang kasi na ang nangyari dito is that the Sandigan Bayan, no, they grant the respondent's motion of particulars as executor of former si yung si the president right now, si Bongbong, no? Kasi siya ang executor of the estate of Marcos. Okay, so ni grant ang motion of particulars. So the Republic, ito yung petition niya, but then it did not commit any grave abuse of discretion. So okay, dapat kasi yung bill of particulars should have a definiteness and with definiteness and particularity. So yun yung topic dito, and we can conclude right now the kasi yung material abatements, no, pagka niya, you can yung tinatawag diyan, you can strike out averments or pag hindi malinaw or yung bill of particulars, you can file uh, motion for bill of particulars so that tawag doon, in order that the court directing the pleader to submit a bill of particulars yung ano nag-complaint, no, na mag-submit siya ng bill of particulars which avers the matters with sufficient definiteness or particularity to enable the movant to properly prepare his responsive pleading. Function, what's the function of bill of particulars? Is a function is to clarify the allegations. Yun. Kasi ano daw, general, no? General law or hindi siya particular. So, clarify the allegation of pleading so an adverse party may inform the certainty of the exact character of the cause of action defense. Without the clarifications of the motion, the movement may deprive the person to submit a diligent responsive pleading. And that it would not be proper for a motion of politicals to call for the production of particulars consisting malice intent. So mayroon din dito regarding the particularity, no? If it's it would not be proper for a motion for bill of particulars to call for the production of particulars constituting yeah. If it constitute malice intent, knowledge or condition of mind, hindi siya hindi, no, under the rules, merong rules ito, that matters shall be averred generally. So yung mga pagka mayroong malice, intent, knowledge, or condition of mind, dapat averred generally lang, no? Pagka sinasabing to require plea to do to require the statement of evidentiary facts in the pleading, ito yung actually ito yung mga statement. This statement here is from the book, no? If you are familiar with the civil procedure books, meron yan. But then I have also omitted yung mga strike out because these are like for example evidentiary facts and evidence or yung mayroong mga changes doon sa ano amendments 2019 amendments of the rules of court. It would not, however, be incorrect to move for a bill of particulars to require the averments of particulars of fraud or mistake, no? So it would not, however, be incorrect, not incorrect, no? Or it would not be incorrect. So it would be correct to move for a bill of particulars to require the averments of particulars circumstances of fraud or mistake. Kung fraud or mistake, under the rules, actually meron tong footnotes but I cannot see if I can see that. Such matters must be alleged with particularity. Ito na yun niya. Ito na siya. Should be alleged with particularity. Kung mayroong fraud or mistake, it's submitted, however, that when the commission of particulars presenting fraud results in the absence of one or more elements of the cause of action, such omission could give rise to a failure to state of cause of action. State of action. Mayroon ba dyan? Wala. Okay. Failure to state cause of action. Okay. Failure to ano ba ba? Delete. Ba tayo? Wala. Okay. So a motion for a bill of particulars is required to require a pleader to set forth matters in the court render judgment is not proper. To set forth matters showing the jurisdiction report. Yeah. So the provisions of Rule 8, Section 6 are clear. In pleading a judgment is sufficient to aver the same, the sitting court showing the should render it. The rule applies in pleading a judgment or decision not only in the district court but also foreign court, like was appealed to judgment decision of a board officer. All right. So I think wrap up. We are now done. And thank you for watching. This is Clifford Enoch. Please subscribe to my YouTube channel. And thank you for watching. This is only for educational purpose only. And I'm in no way magaling dito, no. I'm just learning because I'm still a low student, second year low student, taking up second year in USJ-R, no. The best low school in carbon. The best low school in carbon. Okay, thank you and bye.